Muy buenos días. Para el Instituto de Investigaciones Jurídicas es especialmente satisfactorio tener el día de hoy la presencia de la profesora Kelly Testing, quien es la decana, la directora de la Escuela de Derecho de la Universidad de Seattle. El Instituto de Investigaciones Jurídicas tiene ya desde hace algún tiempo una relación de intercambio con esta Escuela de Derecho y la visita de la profesora es una de estas manifestaciones de intercambio. Como parte de su visita, la profesora ha aceptado dictar una conferencia con el título de New Corporate Governance, Best Practices and Current Issues. Son temas que tienen que ver con la forma en que se gobiernan el régimen de gobierno de las empresas, de las corporaciones. La profesora Testi, como parte de su exposición, va también a dar información y va a presentar su Escuela de Derecho, que es según me manifestaba hace unos momentos, es la Escuela de Derecho más grande del estado de Washington, en la ciudad de Seattle. De manera que, pues sin mucho más trámite, le vamos a ofrecer la palabra. Yo me voy a disculpar de estar presente con ella, pero nos dejamos aquí en su casa. Profesor Testi, please.
Thank you so much.
Please.
Thank you very much, Dean Fix. I'm so pleased to be here today. Good. I want to make sure I was okay in English, and I appreciate your indulgence in that respect. It is a real pleasure to be here today and to be visiting as part of the exchange program of faculty that we have with the Institute. We are very much in awe of the work that you do, and so congratulate you on that and enjoy very much our association. So thank you for having me here today. I wanted to begin by saying just a little bit about who I am and the law school that I come from, so you can have a bit of a picture of what Seattle University School of Law is like in terms of an exchange partner for the Institute. Our law school is a large law school. It is the largest in Washington State. It also has the top ranked in the United States legal writing program. So the attorneys that we graduate are outstanding lawyers who are ready to immediately contribute to the practice of law. And as I think you well know, in the United States, law is a graduate degree, so each of our students comes to us after having already received an undergraduate degree in whatever area of his or her choosing. And so our law school then is a 3-year program following that undergraduate degree. As the largest law school in Washington State, we are a private law school, a private university affiliated with the Jesuits, so a Jesuit Catholic institution, which is a great affiliation in terms of increasing our emphasis on academic excellence. And as a result, we've become one of the most highly ranked law schools within the United States. This year, our law school, there was only one other law school in the entire country that went up higher in the national rankings than we did. And so it's a law school that's very much on the move, very dynamic. And we are known for our academic excellence and also an emphasis on education for justice. As a Jesuit law school, a strong emphasis on social justice is important. And within the program, we have 15 areas of focus. So our students can specialize in areas such as intellectual property and environmental law, labor and employment law, constitutional law, jurisprudence, etc. So a very robust program. And it's a large law school in the number of faculty. We have around 100 full-time faculty that work with the law school. And that includes not only our research faculty, but also our skills training faculty in the law clinic and also in the legal writing program that I mentioned to you. In addition to that, we also have around 100 additional faculty as adjunct faculty, practitioners, lawyers who are in the region who come and teach one class for us in their area of specialty. So it's a very large law school in the sense of the number of faculty and also in terms of students. We have over 1,000, around 1,100 students each year in the law school getting the JD, the Juris Doctor degree. Within the law school, before I became dean of the school, I've been dean of the law school now for around 2 years. Before I became dean, I was a professor for a number of years in the law school. My specialty there is the area of corporate law, corporate governance. And before I became dean, I founded an institute or center within the law school that is known as the Center on Corporations, Law, and Society. So I wanted to mention this to you because it's a great resource in the area of corporate law and governance. It is an academic center within our school, run by a full-time director with a number of affiliated faculty. And one of the programs that the center conducts each year is an annual Directors Training Academy. And this is a training academy that is accredited by the New York Stock Exchange and by NASDAQ, and also by Institutional Shareholder Services. And so it's a very highly rated academy. And within the Pacific Northwest, so within Washington and Oregon, California, other Pacific Northwest states, we train most of the corporate directors in this academy each year. And so I know that you're familiar with a number of the large corporations in our state, such as Starbucks and Microsoft and others. And many of those directors then are trained through our academy. We also have a strong research focus, and so we have a number of visiting fellows within the center, and it is there particularly that I want to say that we're always very happy to host people working in this area and to engage in research cooperatively with persons working in the same areas in other nations. It is a wonderful resource on corporate governance. Our emphasis is on adding value through legal, ethical, and responsible governance. And so I have on the slide there our website. If this is an area of your research, you'll find through that website a number of helpful links and also articles and information to assist you in understanding U.S. corporate governance and also in understanding how it fits within the evolving systems of governance throughout the world. What I wanted to spend some time talking with you today about is the area of corporate governance today in the United States, to give you a little bit of a picture, a snapshot into what's happening now and some of the issues that we expect to be coming forward in the near future. And I'll speak for a few minutes and then open it up to questions in case you have areas that you specifically would like to inquire about. First of all, let me say that corporate governance today in the United States is very much in the context of what we call the wake of Enron. And Enron, as you know, was a very high-profile corporate failure. And at the time that the Enron scandal came forward in the United States, it was not the only corporate scandal at that time. There were many others, including WorldCom, Adelphia, and many other high-profile corporations. And we've seen in the wake of Enron, of course, many criminal prosecutions around those corporate failures, and many reforms that have come forward as a result of those corporate failures. That context is an important one, and it is interesting to me as an academic that part of the language of Enron, most of the time when people write about it, you constantly see people referring to the wake of Enron as if it were just this, huge wave that came as a result of that corporation's collapse and having fallen. And it is certainly true that the collapse of Enron ushered in a tremendous era of change within the United States in the realm of corporate law and governance. First of all, it ushered in an era of legislative change, and in particular the Sarbanes-Oxley Act, which was a very large reform of the way that corporate law and governance were administered in the United States. And I don't have time today to go into every provision of Sarbanes-Oxley. I'm going to mention a few provisions later as I continue. But it also ushered in a tremendous time of cultural change. And in studying the environment for corporate governance in the United States right now, that is one of the things that I think has shifted the most dramatically. And so it's not a law per se, but it's very much a cultural environment that impacts how those laws are interpreted and enforced. And one of the things that I have found most notable about that cultural change is that no longer when courts are talking about shareholder lawsuits or lawsuits for breaches of directors' duties of loyalty or care, no longer do you hear courts talking about plaintiffs being on fishing expeditions or somehow the courts looking at plaintiffs suing corporations as not being worthwhile or not being something that the courts are open to. And I think that in seeing that change within corporate law and governance, that new mindset to being more accepting of lawsuits that allege corporate wrongdoing, that has been a significant change because it's a different standpoint. Now courts are much more open to hearing those claims. And I know that in working as I do in the law school with so many lawyers who are litigating securities lawsuits and corporate lawsuits right now, that is the change that they most often cite as being the most fundamental, that the whole context is really shifted. And the way we talk about corporate wrongdoing and the way that it's accepted in the courts is really a new mindset. I also think that there has been a significant change academically. For many years, those of us who worked in corporate law or corporate governance in the United States were, I would say, kind of second chair to those working in more public law areas, such as constitutional law or even environmental law. But today in the United States, the area of corporate law and governance is really so much at the forefront of what academics are thinking about. And I believe this is due to the growing recognition that corporations have immense power in the world. In many cases, the value, the dollar value of a corporation is much higher than some nation states. And so that focus on, from an academic standpoint, on examining multinational corporations in particular and the law, the regulatory environment that governs them has really expanded quite dramatically. And so today, for instance, in the United States, you will see most every law school adding faculty in the corporate law area. You will see most law schools having conferences or several each year on this area. And so it's really an area that's come up in emphasis within the academic environment in the United States right now. Now, a couple quick notes about some of the legislative changes that I referred to. The most significant, of course, was Sarbanes-Oxley Act of 2002, sometimes called SOX, S-O-X. And the key provisions of that were increased responsibility for financial accuracy by directors and officers of corporations. In other words, making it no longer acceptable to say, I delegated that. I let somebody else take care of those matters. I didn't really know what that was about. Today, directors and officers of corporations must know. There's a much more proactive requirement that those financial statements be certified by those officers. And so that's a very large change within that was wrought by Sarbanes-Oxley Act. And then second, just generally increased oversight of public companies through a new administrative agency. In other words, now the Securities and Exchange Commission is not the only administrative agency looking into what public companies are doing. Also, the Public Company Oversight Board is a new entity that has really added scrutiny to the actions of public companies. In addition to that major piece of legislation, you also have seen over the last several years many changes in stock exchange listing standards. And though these are not at the same level as statutory law, they are certainly as important in terms of what companies do. Because in order to list your shares on the New York Stock Exchange or on NASDAQ, you must comply with these listing standards. And those too have become much more aggressive in terms of what they require. As an example, most of those exchange listing requirements now require that a majority of the board of directors of each corporation, public corporation, be independent. In other words, they not be drawn from management, they be independent from the CEO and from other employees, within the company. The idea being they can exercise more independent judgment then from that standpoint. And then third, the Securities and Exchange Commission has also been very active in the last several years in two senses. One is rule changes. The Securities and Exchange Commission acts by promulgating rules that then get implemented under the two major statutory pieces of legislation, the Securities Act of 1933 and the Securities and Exchange Act of 1934. And there have been a number of rule changes at the SEC level that has also, in the wake of Enron, brought more accountability to U.S. corporations. And one example of an SEC rule recently proposed is to give shareholders more direct democracy, to give shareholders more rights to propose who will be on the board of directors rather than waiting for the existing board or the nominating committee to make that proposal. And so one of the questions that we really have open right now is whether that will proceed to give shareholders more power within the corporation. Not only have the SEC's rules changed, but so have the enforcement priorities. And again, that's more of a cultural shift that we're seeing, in that the SEC is focused very intently upon financial improprieties, financial restatements within public companies. And so most of its resources, which are really quite extensive, are going to those areas of enforcement. Now, let's see, I'm going to actually move past this slide for just a minute and come back to that. Get jumped out of place. Sorry. There we go. Let me now talk about some current issues within this regulatory environment in the wake of Enron. One of them that has drawn tremendous attention in the U.S. in the last couple of years, and is at I think really a high watermark right now, is the issue of executive compensation. And let me say a word about why this came to the forefront. First of all, as you know, when you think about a corporation, the three main constituents are the board of directors, the officers, and the shareholders. And one of the fundamental problems or questions of corporate law has always been, how do we keep management, the officers, and also the board and its oversight role, how do we keep those people working in the interest of shareholders? Because it is shareholders who have invested their money in the corporation. And several years ago, one of the interventions that was made to try and align shareholder interests more closely with management interests was to try and use executive compensation as a way to incentivize corporate management to work for the same goals that shareholders have. And one of the things that you saw as a result of that argument, that if we align shareholder and management interests, management would work more in the interest of shareholders, is a real rise in stock options and other forms of compensation that sought to make management a shareholder. And so, as a result of that, interest in executive compensation issues has really risen quite dramatically. But today, one of the concerns is that compensation is way too high. It's out of step with the value that managers are bringing into the corporate arena. And within the U.S. right now, we're seeing a profound shift in shareholders' desire to have more say over executive compensation. It used to be something that people thought, okay, let's let the board figure that out. That's something that the board can decide, or at most a compensation committee of the board, we would, leave that matter. But today, shareholders want a more active voice in that. Again, a very strong cultural shift in attitude. And part of that has been brought about by increased scandals around stock option pricing. And I'll talk about that again in just a minute. But the worry that executives were basically timing their share ownership based on inside information that all the rest of the shareholders did not have. And so one of the pieces of change that we're seeing is what's called a say on pay legislation that's working its way through the House and Senate in the U.S. meaning that shareholders want to say on what executives are paid. And the way that this bill has been proposed, it would be implemented in 2009 if it were to pass, and it would give shareholders the right to a non-binding vote on the levels of executive compensation that are set. And so a much stronger voice, and obviously the corporation would then know that whatever compensation was set for executives, that would be subject to shareholder scrutiny. That legislation also contemplates more disclosure on what those compensation packages are, particularly around severance packages. Severance not only in the event of employee termination, but also in the event of a merger or acquisition that is going to result in an executive leaving the company. And so higher disclosure around options, higher disclosure around severance packages. And the most recent statistics that I've seen in this current annual meeting season, where corporations are having their annual meetings and shareholders are putting proposals forward, is that around, in most corporations where this has come up for a vote, it's been approved by around 40% of shareholders, which is very high. Prior to Enron, the highest percentage of shareholder approval for any kind of a shareholder proxy proposal was in the teens, at the very highest. And so you can see that moving from around a 10% approval to around a 40% approval, that this has been really quite a dramatic shift and has resulted in much more focus on executive compensation. Another area of current issue that I also wanted to bring out for discussion today is the issue of board oversight, or the role of the board in corporate governance. And as you know, the board is the entity that's vested with ultimate control in a corporation, and they have the duty of both being an advisor but also a monitor of corporate management. And this is an area that continues to receive significant attention. First, pressing forward for the independence of the board from the CEO. Again, pre-Enron, it was very common for the board to just be a rubber stamp for management. Today, that's no longer the case, and that's something that continues to be an area of emphasis, is that independence from management and the CEO. Emphasis on both the advisor role and the monitoring role, asking the board to be really constructively engaged with the firm. In other words, we're not just asking board members to sit there because they're famous. We're asking them to sit there and really help out with the corporate affairs, to decide strategy, not the day-to-day affairs, but those large questions of strategy and planning. And you see just a much more, I would say, hands-on role for the board today. The other point that is interesting to me, and it's an area that I've written on from an academic standpoint, is the diversity of the board. In corporate America, in the United States, corporate boards are still largely composed of white males. There are very few women serving on corporate boards. There are very few people of color serving on boards. And this is something that is really rising in emphasis within the U.S. Companies are actively reaching out to try and diversify their board. And the reason for that is that it is not only, in many people's judgment, the right thing to do, but it is also seen as adding much more value. Because the more perspectives you have on the board, the more that active engagement is really going to make a difference, and it's going to contribute value to the corporation and its direction. And so that's one issue that I want to flag as something that is really taking off in the U.S. in terms of change. There continues to be also a very strong best practices emphasis within boards, and that's why, for instance, we run the Directors Training Academy that I mentioned to you. Boards are actively trying to educate themselves in terms of how to act as a board member, what should each individual be contributing, and how should they be acting as a group. And so those best practices and their development and understanding, that continues to be a strong focus for boards throughout the U.S. Committee structures, thinking about who's on which committee and making sure the expertise is present within that committee to really be helpful. And for instance, one of the most vivid examples of that is with the audit committee of a board, the committee that's responsible for assuring that the financial statements are accurate. Today, it is vital and accepted everywhere that the people on the audit committee must be able to understand financial statements. In other words, we can't just rely upon the accountant to say that everything's okay, but the board member, him or herself, must be able to provide that scrutiny and that analysis. And then finally, risk assessment continues to be an area of great engagement by boards, trying to anticipate the risks that the company is subject to, whether they're market risks, environmental risks, media attention risks, whatever they might be, and put the kind of structures in place to anticipate those risks and also address them if they come to the fore. I mentioned stock options a moment ago. That's going to continue to be an area of emphasis for corporations. Many corporations today now, instead of granting stock options to their executives, are turning instead to granting restricted stock. And so it's a new mechanism of compensating executives through share ownership, but many persons feel it is less subject to opportunistic timing and other kinds of insider trading worries. And so we're seeing a move from granting options to granting restricted stock. I mentioned that there's increased shareholder scrutiny of option grant dates. Again, the worry was there that those dates were being timed through insider information to give executives more advantage than the average shareholder. So there's much more scrutiny of timing on options, and increasing attention being paid to measures to reduce that, including averaging the opening and closing prices rather than letting it being, timed just to a particular point in the day in the trading cycle. Institutional shareholders is another area of current issue. I think that you have seen the dramatic growth of institutional shareholder ownership in the United States over the last many years. I mean, really since the early 90s. Most share ownership in the U.S. is not by individuals, but it's by other institutions, including public pension funds and insurance companies and mutual funds especially. Today, individuals, don't invest so much themselves as they do through one of these intermediaries. And that growth is continuing, and it does indeed give shareholders much more of a voice in corporate governance. And so when we're talking about the ability of shareholders to keep management working in their interest, an institutional shareholder has a much more likely ability to do that than an individual, because owning a huge block of stock will get the attention of management much quicker than a small block of stock, obviously. And then I wanted to mention this Institutional Shareholder Service, also known as ISS, because I think that's an entity that we really need to watch for. Its power is growing tremendously. It's a proxy service that advises institutional investors. And so when there's a vote coming up, ISS basically says, we'll act as your consultant and we'll tell you how to vote. Well, that gives that entity, ISS, a tremendous amount of power. And we saw in the U.S. in the Hewlett-Packard Compaq merger, for instance, that was a couple of years ago now, that ISS really swung the vote in that case. And so I put the website for ISS up on here as well. They're taking an active voice in that debate about having a say on pay, on executive compensation. And so this is an organization, Robert Monks is one of the individuals behind it, that has always had a standpoint of thinking that very strong shareholder voice in corporate governance is the best route to success. And so I think we're going to see this entity of ISS play an ever more important and influential role in corporate governance as we move forward. I mentioned Sarbanes-Oxley earlier it's less current to talk about the impact that it's had on public companies. That impact has, of course, been tremendous. But here I want to mention the tremendous impact that Sarbanes-Oxley is having in the United States on private companies. And this is something that I think is less in the public arena. And the reason is that once the provisions of Sarbanes-Oxley started to filter out into practice, many corporations said, enough of that. I don't want to go through all of those legal requirements. We're going to go private. We're going to take our company private and stay there so that we don't have all these regulations that we have to deal with. Well, one of the interesting things we're finding now is that that's no real remedy either if you don't want to deal with the regulation, because Sarbanes-Oxley, because of the cultural shift in the courts that I mentioned at the start of my lecture, Sarbanes-Oxley is becoming the standard for how companies should be governed, whether those companies are private or even nonprofit corporations within the U.S. And so Sarbanes-Oxley does not apply per se. It's not as if the legislation itself encompasses private companies or nonprofit companies, but the legal standards are nonetheless evolving so that they look very much like Sarbanes-Oxley standards. And so one of the things that we're seeing in the U.S. is that private companies are figuring that the safest way to proceed is simply to go ahead and comply with those provisions, even though they're not technically governed by them. And we're particularly seeing that for private companies that are anticipating an IPO, and so they're anticipating in the near future they'll go public. We're seeing that in companies that do a lot of business with the government, because there is, enhanced scrutiny of their practices under those government contracts. Similarly, in regulated industries, and so, Enron, of course, was in the energy field, and in the energy field and other regulated industries. Even if a company's private, we're seeing, let's line up with Sarbanes-Oxley, even though we don't have to, because it's coming. That's what the courts will expect. It's what our investors will expect. And lender expectations. We're also seeing that for companies anticipating a high level of borrowing, to have access to that capital, whether it's through a bank or through debt offering, again, the safe course that most companies are steering is to go with the Sarbanes-Oxley provisions. And lastly, for companies that are anticipating mergers with public companies. And this is particularly important in the area in Seattle where I work, where there's a lot of technology venture capital companies that are private now, but they all anticipate perhaps being bought out by a larger public company, like a Microsoft, for instance. And so those companies, too, are feeling that hydraulic pressure to go ahead and comply with the higher Sarbanes-Oxley standards. Let me mention just a couple points on the academic side. Academic investigations and research that are becoming increasingly prevalent and important. The first is the shareholder primacy critique. And many in the United States have criticized U.S. corporate governance for being way too focused on the shareholder and ignoring all the other stakeholders like employees and communities, etc. And that is a debate and critique that is really picking up steam. This is an area that I used to write a lot in, and frankly, I was very much a minority voice in the scholarship. Today, it's moving much more into the mainstream. There's much more attention being given to that critique, and much more attention being given to seeking recognition for other stakeholders, and in particular for employees. I think one of the costs of Enron that everyone really felt was the cost that employees bore when losing the job, losing pensions, etc. And so that's something that is very much in the forefront of academic discussion. Kent Greenfield, who's an affiliated scholar with our Center in Corporations, has proposed an interesting new regulation that gives employees similar rights to sue corporations that shareholders enjoy for fraud. And so if a company would lie to an employee, they would be able to be sued under what Professor Greenfield proposed, just like today a shareholder could sue a company if the company lied about the value of that investment. And then third, we're seeing a tremendous emphasis, not only in legal research, but also in business schools and business research, in what is called the triple bottom line emphasis. In other words, thinking not only about the financial, but also about the environmental and the social impacts of business. And the, urging of companies to focus not just on the financial bottom line, but on the triple bottom line. What's your environmental impact? What's your social impact? And it's through this area that we're seeing more and more discussion of corporate social responsibility standards. Of course, internationally, there's been much movement that has happened, but the U.S. companies have been fairly resistant to imposing requirements for corporate social responsibility disclosure. There is, though, within the academic corporate field in the U.S., increasingly an argument that our existing disclosure rules under the Securities and Exchange Act, particularly Section SK of the Management Discussion and Analysis section of proxy statements or filings, there's been many arguments that those provisions already require more disclosure around the impact that corporations are expected to see in corporate social responsibility areas. In other words, asking management to anticipate, do you see that your company is going to have a negative environmental impact? Is your company doing, what are your labor practices? And trying to get companies to disclose more in that realm. There will also, I think, be increasing pressure on U.S. companies to comply with some of the international standards for corporate social responsibility and particularly disclosure of the kinds of commitments that the companies have made. Let me close and then open up for some questions by saying that in the areas that I would anticipate that we're going to be seeing coming up in the next few months and even years in corporate governance discourse, as the wake of Enron subsides. I mean, Enron was a huge change, and obviously when that happens, there's a dramatic reaction to it. But as all things do, that comes, that goes, and that kind of subsides, and we get back to business more as usual. So I anticipate that there will be some rollback in some of the Sarbanes-Oxley provisions, especially some of them that reached most deeply into requiring what companies are seeing as extraordinarily expensive compliance just for the sake of compliance, not for really adding much value. I think, though, that there will, along with that, continue to be emphasis on self-regulation. In other words, getting boards to continue their emphasis on good governance as a way to sort of thwart more regulatory interventions. There will increasingly also be an emphasis on regulatory competition. The world is a global, it's very cliche now to talk about globalization, or the world is a global market. But it is in fact so. And so it is no longer possible for any one country to insist upon, its standards, because capital will just fly to other markets. And we're already seeing that. This is one of the first years ever where there have been more initial public offerings done on the London Stock Exchange than on the New York Stock Exchange. And so in the U.S., that really woke people up, and they thought, have we gone too far? Is there so much regulation here that companies are going to seek to move to other markets because they find that regulation more fair? I do think that in spite of that kind of more turn to business as usual and looking at the corporate directors as the point of responsibility, one of the areas that is going to be increasingly in the public eye in the U.S. is the environment. That's partly that it's an election time of year in the U.S., and Al Gore's back out there with his, book on climate change. There's been so much discussion of climate change, and as the Democrats and Republicans in the U.S. square off for the presidential election, That's going to be an issue that's really in the forefront, and it's going to be not only for the general population, but certainly for corporations within the U.S. And there's already so much discussion about climate change and emissions, and whether companies might work out a system to have only a certain amount of greenhouse gas emissions that are then heavily regulated, and to do more you'd have to buy those from another company. And so that's going to be an area, I think, of intense change. And lastly, let me say that I think even though we may get back to see some rollbacks in our regulatory environment, the cultural change that was brought about by Enron is there to stay. And I think that even though we may see some scaling back, the expectations for public companies especially to be run and well, both in the sense of the financial advantages, but also to be run well in the sense of the footprint they leave on the world with the environment and with the social impact. That shift has really happened, and so I think that's here to stay. So let me close with that and open it up for any questions that you may have. And in doing so, let me again thank you very much for having me with you today.
Thank you very much, Christine Testi. Y lo abrimos a preguntas. Si alguien tiene alguna pregunta o comentario, puede ser en inglés o puedo intentar incluso llevar a cabo la traducción para alguna pregunta para la profesora. Sí.
Yo quisiera preguntarle, para evitar, digamos, otros casos en el futuro, como el de Enron o algunos otros casos sonados, creo que ella hizo mucho énfasis en los aspectos internos de las corporaciones, ¿no? Pero ¿qué pasa alrededor de esto con los objetos externos, es decir, los órganos de vigilancia que tienen que estar muy al pendiente del desarrollo, de la honestidad, de la transparencia de todas y cada una de las operaciones de estas empresas? Es decir, creo que ese no fue un aspecto central en su plática, pues, obviamente, porque había que externar todos los instrumentos internos que tiene la empresa. Pero ¿qué pasa en lo externo, no? Ese es un...
And translate this. He's asking that to avoid other cases such as Enron, what do we have to do, or what do corporations have to do regarding external bodies or external aspects of the corporation? Because he's mentioning that in your talk you highlighted internal rules that all corporations have to put forward to avoid such cases at Enron, but he's asking for external bodies that also have to be modified.
Sure. Let me say about your question in terms of what about the external. Some people think that Enron would have happened even if Enron's board had done everything it should have done. In other words, that the Enron failure was not about corporate governance. It was about being in a risky environment and that's part of why we, sometimes make great profits in business, because we take great risk. And so I think that one of the things we do have to understand is that the best corporate governance in the world is not going to make sure that companies always make profits and don't fail. There will be corporate failures nonetheless. And what that then means is that you look to external bodies, right? So what is it that happens when those failures occur? And I think that it has been, again, I think a huge wake-up call in the United States in terms of the other regulatory entities that were asleep at the wheel. They really weren't being watchful. And so along with the corporate governance reforms that we're seeing, we're also seeing a culture of increased responsibility within government and agencies, and I don't at all for a minute claim that we're there yet, but I think that there's attention being paid to just saying, let's at least, you know, be somewhat of a watchdog, and let's make sure that we're at least complying with the other external laws that are already on the books. You know, much of what is being sought is just legal compliance with what's already there and good enforcement of those legal rules. And so that's a very important question and very important piece of the puzzle.
¿Alguna otra pregunta o duda, comentario? Sí.
So, from what I understand, you are saying that maybe even if like the government, next government signs or doesn't sign the Kyoto Protocol, that corporations may do these adjustments by themselves because of all these social awareness in the U.S. that may happen.
Yes, I think that. I think it's you know, if I were advising the U.S., I would say that we should sign on to those protocols that, you know, we say are good ideas, right? But I think that even if that doesn't happen as a formal matter, the cultural change has been so significant that I think most companies are going to be doing that as well. And one of the things that's really driving that is that there's recently been a study that corporations in the United States that pay attention to corporate social responsibility are outperforming those who don't in the marketplace. And so not only are you going to have the cultural pressure for that to occur, you've got the market pressure for that to occur as well. And also increasing pressure internationally to say, why aren't you doing this too? And so I think those three things together may make the difference.
¿Alguna otra pregunta o comentario? No. Well, thank you very much,
Thank you.
Jean, and gracias a ustedes por su asistencia.
Gracias. Thank you very much.